Next from Chicago, former Governor Pat Quinn offers his own legislative redistricting plan that he says will pass the muster of the state constitution. This runs about 25 minutes.
And I want to thank everyone for coming. And my name is Pat Quinn, and I'm somebody who's been passing petitions in Illinois for the past 40 years. I believe that voters in our state should have a chance to vote not only for candidates, which is very, very important, obviously, here in the presidential year, but also have a chance to vote on issues. And that's what petition and referendum is all about. And in my time since I left as governor, I got to read part of a biography of a governor of Illinois back, it was in 1913. His name was Edward Dunn. And he, like myself, believed in the power of petition and referendum, and he tried to get in our state what's called initiative and referendum. And it failed by one vote. Actually, they had the vote, and the person changed their vote before it was officially certified in 1913. So I always, when I learned of this, it was with deep regret that we did not have for the past 100 years the power that many other states, particularly here in the Midwest, states like Missouri and Michigan, Ohio, neighboring states have a power at the state level and at the local level where citizens can petition and put issues on the ballot and then enact them into law if they feel that they're worthy. However, as you may know, in 1970, the delegates to the Illinois Constitutional Convention did consider a full-fledged initiative that did not pass the convention, but then several of the delegates felt that there at least ought to be something in the Constitution, the new Constitution, that would allow the voters to put on the ballot referendums that would reform legislative processes, the legislature itself. And this was enacted by the convention. It was approved by the voters in 1970. On December 16th of 1970, and it became the Constitution of Illinois, and it marked the first time in the history of our state that voters at the statewide level could actually petition for binding referendums where they would enact the constitutional amendment. We tried that in 1976 for the first time. It was a case of first impression before the Illinois Supreme Court, and the court held that ethics could not be enacted by initiative. It was a very difficult decision to accept. We had gathered 635,158 signatures, all-time high in Illinois for three measures, constitutional amendments that would have ended advance pay for legislators, stopped double dipping, and prevented legislators from voting on bills where they had a conflict of interest. The court back then said you could not initiate, the people couldn't, ethics measures. It was disappointing. This time of year, I always think of that. It was 40 years ago, just about today. But we kept going. We had a great group of people who passed petitions and believed in the power of referendum, and we kept on petition passing on important issues. And in 1980, we were able to gather nearly 500,000 signatures for what was called the Cutback Amendment. It's a constitutional amendment that reduced the size of the Illinois House from 177 members to 118, and it also required each of those members to be elected from a single-member district. That was a highly contested battle. The General Assembly, in the middle of our petition drive, radically changed petition passing law in Illinois, made it very difficult to even circulate a petition. I think one person said if the person you're trying to get to sign your petition wasn't of the same blood type as the circulator, they couldn't get the signature. But we thought it was way overboard, unconstitutional. We fought all the way to the Illinois Supreme Court. And about this time in 1980, 36 years ago, the Illinois Supreme Court struck down that anti-petition passing law and put the Cutback Amendment on the ballot. And the people voted for it in November of 1980 by a huge margin, more than 2 to 1. I think it was about 68%. And that marks the only time in state history since 1818 that voters have put a binding referendum on the statewide ballot and enacted that by their votes in a referendum. Nothing has happened since, and nothing happened before. And I think it's very unfortunate. I know exactly how the people who were promoting the independent maps referendum feel. When you put all that effort in to get 500,000 or more names on a petition, and then it doesn't get on the ballot for the voters to have their chance to vote for it, it's a severe disappointment. But I think it is important to kind of take a lesson from our experience and my experience that you never give up. And I think it is important to have redistricting reform in Illinois, to have voters have a chance to vote on this issue. Because we know from, I guess, 2 years ago and now this year, there have been 2 tries that have fallen short. And I think basically the court, in its decision and opinion last week, made it pretty clear that you have to comply with every part of the Illinois Constitution if you're going to get a redistricting referendum on the ballot for the voters to vote on. Now, this was the measure that was declared unconstitutional last week. In my view, and I mentioned this to some of the people I met along the way, the drafters and such, that it's very complicated, very long, and it is now unconstitutional. So I don't think this is the method to go for in trying to get a referendum on the ballot that is binding in Illinois that would reform redistricting. And I think that is a worthy task. So today I've drafted up a fair redistricting amendment that can be petitioned for when the time comes. Right now you cannot, under Illinois' Constitution, circulate petitions for any constitutional amendment. You have to wait until 2 years before the next election. But this fair redistricting amendment is quite a bit, I would say, simpler, cleaner, and pristine. And I think it is important to have something that's lean and clean and pristine if you're going to amend the Illinois Constitution when it comes to redistricting. So under this proposal that I've drafted, and I have reached out to some of the advocates of the independent maps. I talked to one yesterday in particular, and I said, don't give up. This is a subject worth voting on. People want to vote on it by their signatures this year. They made that, I think, crystal clear. But we have to do it the way the court has outlined. You cannot change a constitution unless you do it according to the rules of the Constitution. So to look at the proposal that I've drafted, it basically eliminates any role whatsoever for the General Assembly to have votes with respect to redistricting. What it does is it says on February 10th of the year following the census, so it would be February 10th of 2021, the next census is in 2020, but on February 10th, the Illinois Supreme Court, as a court, would name 11 people to a fair map redistricting commission, a fair redistricting commission. 11 people, no more than 6 can be of the same political party. The court itself would do this, not just the Chief Justice or some other justice. It would be all of the members of the Supreme Court would have to propose 11 names for this commission. And that would be certified to the Secretary of State. And those men and women would have for 6 months until August 10th the opportunity to have hearings and then to draw a map of the legislative districts, Senate and House, in the state of Illinois. And when they file that map on August 10th, that would be presumed valid. It would not go to the legislature. It would be automatically filed with the Secretary of State, presumed valid, and have force and effect for the elections under the new redistricting map. This is a very simple, straightforward process. Doesn't add people like the Auditor General or others that tripped up the last constitutional amendment. The whole idea is to have a group of men and women, good and true, much like a jury, pick the districts or draw the districts in Illinois. Under the proposal in this constitutional amendment that I have outlined here, you would need 7 of the 11, so that's more than 60%, to approve the map. So they would have 6 months to come up with this process. The Attorney General's role is still preserved if there are any issues that come up. Same way with the Supreme Court. It would have exclusive jurisdiction of any challenges to the map drawn by the Fair Redistricting Commission. But in doing this, I think if you read the Supreme Court case, as I did last week and recently as well, the majority, I think, made it pretty clear that redistricting itself is not off limits for people to petition a question onto the ballot. But the particular question that was attempted last week had some constitutional defects, so the court ruled it off the ballot. So I do believe that there is an opportunity to do this. The constitutional debates made it pretty clear that redistricting reform was a valid subject if done properly, and I think it is worth taking this cause up when time comes to pass petitions again, that we should all gather together in Illinois, do it along the way that I've outlined, I think is the proper way and the cleanest way, the simplest way, and the best way to get reform that Illinois citizens, I think, want in great numbers. So that's what I'm proposing today. I plan to talk to some of the other sponsors and petition passers with the Independent Maps group to encourage them to kind of follow this outline. I think if they do, they will have the same result we had in 1980. After a long, hard battle, we were able to win passage of a constitutional amendment that was petitioned for by the people and voted on by the people in the best traditions of Illinois democracy. So if you have any questions, glad to answer them.
Yeah, in light of the Strokes grant, why would letting the Supreme Court appoint the commission make it less political than the current system?
Well, under the current system, if there is a deadlock of a commission, right now it's an 8-person commission, 4 appointed by the Democrats, 4 appointed by the Republicans. If they have a deadlock, then the Supreme Court today nominates 2 people, 1 Democrat, 1 Republican, and their names are put in a hat, Abraham Lincoln's stovepipe hat. And this has happened now 3 times, in 1981, 1991, and 2001, where they reach into the hat and pull out the name of the tiebreaker, either a Democrat or Republican. A Democrat was picked in 1981, and a Republican was picked in 1991, and a Democrat was picked in 2001. I think the constitutional drafters never thought in a million years this would ever happen. They thought the very fact you'd have this tiebreaker system would encourage compromise. It clearly hasn't worked. And so I think it is time, after having a constitution now for 46 years, and if it isn't working when it comes to drawing the maps, that we should give the Supreme Court, which already has nominating power for the tiebreaker, to just give them the nominating power for a commission of 11 people, the same number as Independent Maps proposed on a commission, and say that 7 people have to agree on a map for it to become effective. And that is, again, what the Independent Maps people are calling for. The key is to have the Supreme Court judges, all 7 of them, come together and nominate these 11 people. They've done this in other kind of occasions in the past, and even court cases. And keep in mind, the Supreme Court judges are elected in the first place, and they must serve, after 10 years, they must be retained by the voters in an election. And so there is some political accountability there for the judges themselves. They are not there for life unless they're retained by the voters after 10 years. So I think this is an accountable system. It's very simple, and it is the best way to break the gridlock.
Did you base this on any other state, as they've tried to also come up with something?
Well, I've looked at other states. We have to keep in mind that the Illinois Constitution is unique in giving voters the initiative and referendum power only for the legislative article of the Constitution. And the way the courts have interpreted this over 40 years, they've kind of narrowed where you can go, even with that power of initiative and referendum on the legislative article. And so the judges, I think, the other day, the majority said this redistricting remap proposal, it goes beyond the parameters of the legislative article of the Constitution, and that's why they struck it down. But the judge who wrote the opinion, Justice, he made it pretty clear that there are other methods of doing this. Other states have different systems, but in order to comply with our Constitution, I think you have to kind of take the four corners of what's in the Constitution today on redistricting. If you look at the Constitution, it's, has a system, and what I've done with this amendment is basically take out a lot of words without adding a lot of verbiage, which the independent maps, that's a lot of verbiage, and I think that tripped them up by removing words and giving the Supreme Court the duty of naming the commission, and then saying that all the other powers of the officers of the state of Illinois, like the Attorney General, are preserved. I think that is a better way to go than what we had before.
How awkward is it for you to be agreeing about something with Bruce Raumer?
Well, he doesn't, I hope he agrees with this. I think anyone who's truly concerned about remapping reform, district reform, should go along with the proposal that I've outlined. It's called the Fair Redistricting Amendment. I have experience in getting this done, and I haven't seen that happen in his case. He can talk about things, but you got to have outcomes. So the goal is to have a good outcome. And I really feel that in order to do this right in Illinois, we have to comply with the Constitution, adhere to the Supreme Court opinions, activate the voters to get signatures on petitions for the next time at this. The number of signatures would be about the same, 300,000 you need minimum. And it should be a bipartisan, nonpartisan effort. And there's lots of people who can do that and want to do that in Illinois, and I think they should have hope and not be hopeless.
Why didn't you propose this earlier, like when the current map was being drawn and you were in office?
Well, the whole idea of the Constitution was to try and get legislators to agree on a map without having the tie-breaking provision employed. And in 2011, that did not, there wasn't a tie-breaking commission. The legislature did pass a map. I looked at it very carefully, both at the state and federal level, and I studied it. And I decided that it was complying with the Constitution. The districts were substantially equal in population, they were contiguous, and they were compact. And courts, after I acted, upheld the maps as well. So that is how it happened before, but I think we have to look at the history of Illinois redistricting. As I mentioned, 1981, 91, 2001. So 3 out of 4 times you've had this tiebreaker. And I think also you look at where people are. If the voters go out and get 500,000 or more names on a petition, that's worth looking at. And we should have, in my opinion, much broader initiative and referendum rights for people in Illinois to vote on issues at the state and at the local level. I'm passing a petition right now for a binding referendum here in Chicago, where I live, on term limits for the mayor and electing a consumer advocate. That's provided for in this Constitution. And we need to broaden this power. Too often I think the powers that be have resisted giving voters the chance to vote on issues as well as candidates. So that's a lifelong cause for me. And the way you exemplify it is go out and pass petitions and show how it's done.
Okay. This last attempt at independent maps was purposely, there's this idea that they may have purposely written it so that it would fail, just to keep the issue alive because it's popular. And I'm wondering if that's, do you agree with that assessment?
I don't think so. I think the people I encountered who were circulating the petition or signing it, they in good faith believe in the cause. I did run into one of the lawyers for the group, and I asked her, why did you put the Auditor General in there? That was just sort of asking for trouble. And she said, it was a group effort when it came to drafting the amendment, and that sometimes happens. But I just think this, we know, is unconstitutional, and people work so hard to try and get it on the ballot. Okay, we got the word from the Supreme Court. What we want to do now is learn from that and come up with something that's simple, clean, and pristine. That's what this is. Leaner and cleaner, okay? You got the message there? Okay. If you do it that way, you have a better chance of getting on the ballot.
Sorry. Governor, are you prepared for complaints that your system might disenfranchise minority voters?
Well, when I was governor, I signed bills into law with respect to the law of Illinois on redistricting. And a commission would have to adhere to those standards as well as anyone else. And some of the law provisions that I signed were designed to protect everyone's right to get candidates of their choice and to have redistricting. The law was called the Chinatown Law when I signed it, but for years and years, Chinatown was divided into 4 parts in districts, 4 different districts. And we tried to, by law, remedy that, and I signed that into law. And this year, a person of Chinese American was nominated in the primary. And so I felt that that helped make the process fair. But I do think you always have to have courts at the state and federal level available if anybody, including a commission, draws a district that is biased against any racial group, racial minority. You can go to court. And matter of fact, under the Illinois Constitution, there's still, under our proposal, the right, you can go directly to the Supreme Court and make a claim against the redistricting map. The court would still have exclusive jurisdiction and could act promptly. The way this would work is if August 10th people know what the districts are, then they can start passing petitions to get on the ballot.
So independent maps just sent out a thing saying they're going to request a rehearing in the Supreme Court. So how can you kind of push your plan ahead and not have it be another competing?
Well, I've been there on that one too. We didn't win in 1976, and we petitioned for rehearing. The court didn't grant it. It's very rare. It could happen, but you're on the 1-yard line and you're trying to drop back in the end zone and throw a 100-yard touchdown pass with rehearing. So, it's always worth a try. If you're a lawyer, you try everything on behalf of your client, but you don't want to depend on that. I think, as I told a friend yesterday who was very involved in this, it's better to sort of study what the court said, see what the rules are, and then draft something that fits in those rules. And I think that's really what's going to happen. It's better to happen that way.
Independent maps folks don't adopt your language. Would you go out and circulate petitions with your language?
Well, I don't want to presume anything, and I think it's better for folks who, I know what it's like to lose a case in the Supreme Court when it comes to putting a referendum on the ballot. I know exactly how they feel. It's very hard, and it takes a little while to kind of bind up the wounds. But ultimately, I think it's worthy, our idea is worthy of careful study, and I'd be happy to work with any group that would be petitioning for something that's substantially the same as this. I think it's needed in Illinois because we've had this history of going to the edge of the cliff over and over again, and I don't think that's healthy.
I don't want to make an assumption. Why did you at the beginning talk about that you want to eliminate the General Assembly, the role of the General Assembly?
Well, I think the essence of what the independent maps folks have talked about is that when politicians have to draw districts for themselves, too often there is a temptation, at least, to worry more about the office holder than the voters. And so rather than draw districts that favor the office holder, we should seek to draw districts that are in the best interest of the voters. That's really been the impetus in recent years of commissions in some states across the country, including Arizona recently was upheld by the U.S. Supreme Court, to have a commission that is not made up of legislators drawing the maps. It's a very sensitive subject for a lot of office holders, and they don't want to lose their office, and so they have a very active interest in what streets are in their district and what streets are not. And so rather than have them draw the map, it's better to remove them from the process and have people who don't have any conflict whatsoever. And I understand what that is, and I think that's a movement that's growing across America. I think we really should have it at the federal level, and it would be really good if it was for every state. So if Illinois has a redistricting reform for federal offices, I would hope Texas and Florida and other states would have it as well. Okay. All right. Well, listen, thank you for coming. It's good to be back here. And this man over there, Bill Cameron, was around in 1976 covering our first petition drive. So there you go. History repeats itself.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.